Good morning, Danielle Beach, speaking to you from Beach Oswald Immigration Law. And I've been an immigration attorney for about 30 years and practicing all areas of immigration law. Today we're going to talk about prosecutorial discretion, which a new memo came out, which requires all government attorneys to work with private attorneys and to come up with a plan for how they want to handle cases. So this is based on enforcement. So for example, people get issued notices to appeal, and then they would be put into deportation based on maybe an immigration interview or an asylum interview or some other case, and they would be then, if they had no relief, have to either take voluntary departure or be deported. Well, this gives the government leeway and ability to choose whether or not they will enforce this kind of case or whether they will terminate the case. And one of the reasons this is so popular right now is because there is a huge backlog in the immigration courts. And that backlog, if you're in an immigration court, you know that your case may be seen or heard 2025. So you're talking about a huge backlog. And sometimes those cases will then get continued again. And especially with COVID, it just got worse. So they're trying to give the government and private counsel and the courts a way of terminating cases that maybe don't need to be enforced, and not putting cases into deportation that maybe don't need to be put into deportation. So it's not the government's job to offer this. It's your attorney's job to contact the government and explain to them why you fit into this prosecutorial discretion and why it should be exercised on your behalf. So don't think that you're just going to go there to court and they're just going to give it to you. That's not the way this works. So USCIS has been given also a memo which encourages them to expedite cases and look at case by case to determine if there are mitigating or if there are aggravating factors. So what are mitigating and aggravating factors? This is brand new, and I always thought it was very strange that if you go to Europe, a person who's been there 30 years is treated very differently than someone who just came in 1 year ago. Not in the US. You could have been here 30 years and you were treated no differently than if you had been here 1 year. So this now includes factors, and I'm going to go through these factors quickly. So first of all, length of residency in the US. So if you've been here a long time and you've stayed here a long time, that is a factor that should give you prosecutorial discretion. So sometimes in the past, what immigration has said, look, when you got deported, you had this situation, but now you've taken advantage of it. And so 10 years later, you're trying to ask for relief because you married a US citizen or whatever. And, you've taken advantage of it. I think this may help with that. Second factor is if you've served in the military or have family that serves in the military. Third factor, do you have family or community ties in the US? So do you have a US citizen spouse or child or parent? In the past, that might help or might not have helped, but now they're saying this is a factor. Fourthly, have you been a victim? Like, are you a U visa? Have you been a victim of an aggravated assault or something? Then you would not be able to be deported in certain circumstances. What is your immigration history? Have you had a clean immigration history for the most part with minor altercations? That will be looked at. Very interesting one. Are you the primary caregiver of a child or elderly relative? Very interesting, because many people are. And if you did have a sick child or parent, it didn't seem to matter, because they would say, well, the child or parent who's a U.S. citizen can stay and you have to go back home. Well, now this is a mitigating factor, so very interesting. If you were seriously ill or you have medical problems yourself, maybe you had a stroke, maybe you have another issue, that would be also a factor. Compelling humanitarian factors such as your age, if you're older, or if you're very young maybe, or if you are pregnant, or if you're in bad health. These are all mitigating factors. And then we look at people who have aggravating factors. These are people who have a criminal record, but perhaps they have had some minor things or major things, and they are now required to look at the seriousness, and your attorney, if he's good, should present why this crime is not so serious. How much time has passed since this crime occurred? How have you taken steps to rehabilitate? So, for example, say you had a drunk driving. What steps have you taken to make sure that this doesn't happen again? How much time did you serve? What were the circumstances of this? In the past, it was just the crime was the crime, and they didn't look at any of these factors. So this is great because it allows new factors to be looked at. So again, if you see an attorney and you are in deportation, or you're not in deportation and you don't have a simple path to green card, your attorney should be talking to you about prosecutorial discretion and how this can help you. We are happy and delighted to work with these kind of cases. I've worked with these kind of cases for many years, and they're sometimes the most difficult types of cases to overturn and to get to a successful result. But I would be delighted to work with you. So keep that in mind. Prosecutorial discretion has always existed, but now it's a whole new world with prosecutorial discretion and many new opportunities. Thank you for listening to this, and I hope it's been helpful to you in some ways. And if you have friends who need help, I'd be happy to help them also.